Alrighty, let's get started. Again, good afternoon, everybody. Andy Bobreck here. Good to be with you. Good to have you with us for another installment of our weekly webinar program. We've got an interesting, I believe, program for you today. I'm going to start with some overview of the New York State budget that passed recently, and with particular focus on the labor and employment realm and issues that you may have been tracking or keeping tabs on. I have my friend and partner, Lou DiLorenzo, joining us today too. Lou's going to talk about, I think, an important issue that a lot of you all will face from time to time, that dealing with employee paid time off and specifically vacation, and the important principles to keep in mind under New York law. And then finally, I'll finish up with an update on where things stand with COVID and one development there that we wanted to report on. So without further ado, I guess I'll start here. This is a picture of my backyard this morning. For those of you who are in upstate, you probably saw something similar to this. It is a little bit dispiriting. Born and raised here in upstate New York, and every year this seems to happen, and every year it does happen. I think a little piece of me dies along the way when I see this come spring. My poor daffodils there, you can see at the bottom of the tree. I don't think they're going to make it, Lou, but fingers crossed. We'll see. But I should say we fared better than a lot of other areas in upstate. Members of our own staff got a ton of snow, power's out, so we wish them the best and hope everybody's doing okay with the weather today. All right, so without further ado, I want to talk a little bit about the budget. The budget was passed, I believe, on April 9th. It was about a week late than usual. It was $220 billion, which, again, just is an incredible amount of money when you think about it. And there's a lot in there. And I guess my takeaway from a high elevation standpoint right now is that usually we see a lot of nuggets and bits and pieces that are tucked into the budget bill. Seems to be the principal way that a lot of legislating gets done these days in New York. And I guess in contrast with years past, we didn't see as much in the final budget bill as we expected and as we've typically seen in years past. What we did see that we thought would be of general interest, and again, this is not an exhaustive summary of everything, but just some things for you to keep in mind. There is a minimum wage increase for certain home care workers. That's going to be about a $3 increase that's implemented over the course of 2 years. There's an enhancement that was contemplated for partial unemployment insurance benefits. So again, allowing certain workers who may work a part of the time during a week to still be eligible, whereas before they may have been disqualified for receiving benefits. And in that particular provision, the effective date has been postponed back into 2023, I believe. With respect to Tier 6 and public sector workers at state and local governments, there was an adjustment to the pension eligibility formula. Again, more detail on that than we want to go into here, but something to keep in mind. And then another big issue, one that I know Lou's been dealing with and I've been dealing with a number of clients, and that being these state-sponsored bonus payments for frontline healthcare workers and mental hygiene workers. Again, there's various bonuses and incentives that are going to be state-funded and made available for participating and covered employers, including those in the private sector, that they can then distribute these bonuses to their staff. There's quite a few issues that come up here, not the least of which is how you handle these payments with respect to non-exempt employees who are paid on an hourly basis and who may be eligible for overtime payments. So on those, we encourage you to work with your favorite bond attorney here. Feel free to contact me, contact Lou if you have any questions, if you happen to be in an institution participating in that particular program. So when we started to look at the budget, there were a number of things that we were concerned about. And I think at the top of the list with respect to that concern were certain prohibitions that were proposed in the original budget dealing with non-competes, as well as some no rehire or no poach covenants. Again, these are common features that we see in employment agreements and other incentive programs. Again, very commonplace here in New York and ultimately serve a valid and important purpose. But these were going to be constraints that were placed on employers and businesses and organizations that had these types of agreements on the books and that wanted to moving forward. So I guess the good news is, at least for now, those particular prohibitions were not included in the state budget. We'll have to remain and watch and see what may happen there moving forward in the legislature, but they were not included in the budget. Also, there was a provision that was proposed in the original budget that would have increased the criminal penalties for wage underpayments under the New York labor law. There is already monetary penalties as well as potential criminal penalties for knowing violations and knowing underpayments under the New York labor law. Those have been on the books for some time, and I should add that that can apply right to individuals as well. There could be individual liability on the criminal side for knowing violations of the labor law, but those enhanced penalties also did not pass. So, like I said, it was, to me, an interesting budget season here in that we really didn't see as much coming out of the budget as we've seen in years past when it comes to the labor and employment realm. Again, we'll keep our ear to the rail on all things in Albany, and if there are any additional developments, we'll be sure to let you know. I did get a question. I will try to push a link out to the budget bill itself. When you access that link, prepare yourself. You're talking over 300 pages of small text, so get those reading glasses out if you want to pour through it. I expect we will have an update on our blog as well with respect to the budget legislation. If you want to tune into that, it's the New York Labor and Employment Law Report. All right, so once again, it's my pleasure to welcome my friend and colleague Lou DiLorenzo to the webinar today. Lou, as you know, is one of the authors and the principal driving force behind the book that our firm published, New York Employment Law, The Essential Guide. This is a book that we published through the New York State Bar Association. Again, just to be clear, we don't receive any royalties or funds from the sale of this book, but Lou spearheaded this effort as a service to the labor employment community and to provide a resource to you all. So today, Lou's joining us and wanted to talk about an important issue that we will face from time to time that can deal with a myriad of compliance issues, but that dealing with employee vacation time. So Lou, great to have you with us. Thanks for joining.
Thanks, Andy. Someday I'm going to get some exciting topics here for you on this program. Today we're going to do vacation. Actually, I asked Andy for the opportunity to talk about vacations because it's an area that I run into with new clients, sometimes negotiating a first labor agreement or just drafting a handbook or being involved in an issue with a terminated employee, and there's some complications with vacations. So I'm going to talk to you about some important principles I think for you to keep in mind and do a check in your organization. Hopefully you're in good shape, but I want to give you some ideas to take your own blood pressure and temperature in terms of how good or bad your vacation policy is or how you can improve it or think about improving it. I'm not going to tell you how your vacation policy should be. I mean, every workplace has its own culture, its own needs, and its own vacation policy as to what should be needed. But let's start off with a couple of things that are important that are, frankly, misconceptions, I think, under New York law. New York State is very, very pro-employer, I'll call it, with respect to vacation policy. Basically, it's still the wild, wild west. If you draft a policy and you communicate it in writing to your employees, whether by posting or handbook or distribute a policy or have them sign something or put it in their employment agreement or whatever you do, as long as that policy is in writing, you pretty much can enforce it. In other words, there's no basic entitlement to vacation, if you will. And I'm going to talk to you about some of the things that we've run into that can cost you some money if you don't pay attention to them. So the first one, as I said, is that you can pretty much do what you want. You will see in the New York cases and even on the Department of Labor website that no one is entitled to vacation. There's no birthright that says we're entitled to 1 week's vacation after 1 year and 3 after 10 year or 2 after 10 year. There's no entitlement to vacation. Because it's considered under New York law, pay for not working time. That's why we get this flexibility to do what we want. So let's start off with the idea, there's no birthright. There's no minimum number of vacation days people are entitled to no matter how much they work. Number two, and this is more of a De Lorenzo corollary than it is, you'll find it, I've looked for cases, I haven't been able to find it, but to me, vacation is supposed to be a paid respite from work. In other words, I don't want you to work. I want you to take paid vacation, restore yourself, refresh yourself, and return to work ready to go back to work after your vacation. That's why I give you vacation time. I don't give it to you to store up for 50 years, and when you retire, you get a huge payout as part of your pension for all this accrued vacation you've got that you never took. That's not the purpose of it. It's not to be hoarded. It's not to be used as a pension or severance benefit. It's a paid respite from work. And to work properly, it should be taken every year. So if someone says to me, draft a policy that you want us to have or you think we should have, and we'll see if it matches our culture, one of the first things I have is there's no carryover from vacation. You use it or you lose it, because I'm not going to have you carry it into the next decade because you didn't use it. So there's two problems with letting people carry over, for example, unlimited vacation. One, you end up with a tremendous unfunded liability that your accountants may pick up someday and say, wait a minute, you've got $300,000 worth of accrued and unused vacation on the books that you owe your employees when they quit, when they retire, when they leave, or when you fire them. Secondly, let's not forget that if I'm paying somebody $20 an hour this year and they bank 10 days of vacation, 10 years from now when they take it, or when you pay it out to them when they quit or leave or you terminate them, we're going to talk about those policies, you're going to pay the vacation out at $30 an hour because that's what they were making when they left, or $40 an hour. So the vacation gets earned at a lower rate, and years later it gets paid out at a much higher rate because that's the salary that the person is earning at the time that they leave and you cash out the vacation. So we've already mentioned a couple of things here. You want to have some kind of a carryover policy. Is it use it or lose it? Is it you can carry over 4 or 5 days? Is it you can only carry over days with specific approval where you tried to schedule the vacation? I stopped you twice because it wasn't convenient for us, and you didn't get a chance to get your vacation in before the end of the year, and you want to give the person a chance to use it next year because it was really, I frustrated their ability to take the vacation. That policy might say it has to be taken in the first quarter of the following year. You know, take a look at how you want to monitor that and take care of it. Of course, whatever vacation policy you have should be subject to the operational needs of the employer and being able to approve vacation and how many people can we have out on vacation at one time in a particular unit, department, so on. So you want to manage that. Some people often have preferential vacation periods. Some people worry about, should we give it to everybody first come, first serve? Should we, usually under the labor contracts, because seniority is so sacrosanct in a labor contract, the union will typically want their people, their senior people, to be able to pick the best vacation times. In Central New York, based on the picture you just saw from Andy, they all wanted 4th of July week when there's no snow and the snowing equipment has been put away for the week. So if you have a strict seniority provision in the labor contract or in your policy, it's unfortunate because, it can be a retention problem. Less senior people don't get a chance to have some high profile time. So oftentimes what people do is set up a preferential period, which can be so many slots are available during prime time, and people can request that in advance. And that might be first come, first served. After that, or with conflicts, seniority get resolved in that. But if you got people that really want to take a trip to Disney World with their family and buy the tickets and plan it, even if they don't have a lot of seniority, they can lock it in and know that they're going to go and nobody's going to be able to bump them out of that spot. So you've got the scheduling issue, which again is up to you to decide how you want to fairly do that. You want to talk about how much you let be carried over from year to year. Maybe it's nothing, or maybe it's a small portion, or maybe there's a maximum. You can carry over 5 days, and you can never have accumulated in your vacation bank, if you will, more than 5 days at any time. So there's a modified use it or lose it. Once we get to a maximum of 5, you start to lose the days if you don't use them. And if you've had, bad hygiene practices going into this, and today you're learning this for the first time, you can set up programs. I've had some clients with very serious accumulated vacation time in people's banks and a lot of long-term employees. So rather than try to just wipe that out, what we've done is put in an accelerated policy where they're allowed to take additional vacation over the next 3 years to get rid of what they've got, and address that that situation. The other thing you can do, so it's carryover issue, right? How much are we going to let them bank? Number 2 is, are we going to even pay it out when they terminate? When somebody quits or retires, there's no obligation to pay them the vacation pay. Now, you'll hear the black letter rule in New York. Well, if it's accrued vacation, they earned it, you have to pay them when they quit or when the employment ends. That's true unless you have a written policy that says it's not true. In other words, we don't have to pay vacation out at all. And nobody's entitled to get that money. Remember, it's a paid respite from work. If you don't work for me anymore, I don't have to give you the time off with pay. So you have to deal with that pay issue. How are we going to handle the pay issue? Secondly, you might modify that pay issue. For example, the 2 big reasons I see that people may not want to automatically guarantee vacation pay when somebody leaves is if we fire them for cause or fire them for misconduct. To add insult to injury, I fire somebody for embezzling money, and my vacation policy says I have to pay them 100 accrued vacation days on top of it. Those are unhappy clients when they call us and say, all the money we pay you, this is what you're going to tell us we got to do with this, Steve. Well, it's earned wages. If your policy doesn't say there's a forfeiture, and we haven't communicated that to the employees, there are civil and criminal penalties for not paying employees the wages that we owe them. And if you don't have a forfeiture policy in your vacation plan for terminations for cause or misconduct, then you are illegally withholding wages that the employee earned. Now, if there were a faithless servant issue here where they engaged in some disloyalty, or some misconduct that went to the very roots of the duty of loyalty and fidelity they owed their employer, we might be able to cut off a whole bunch of things from the date of the disloyalty or the infidelity, if you will. Might even precede the termination. It might affect compensation and so on. But short of that, embezzlement was a bad example, because embezzlement will qualify for the operation of the faithless servant rule, which would result in, if we exercised it, forfeiture of compensation. But otherwise, we've got to pay it. So you might think about paying it, except where they've engaged in misconduct, just cause. You also have to think about how the policy is written. For example, some policies, we end up prorating a vacation day. So let's say that after 1 year of service, you get a week. After 5 years of service, you go to 2 weeks. And I terminate somebody in March of or April of 2022. There's a question of whether my policy requires that I pay them for some unused vacation from last year that they haven't used yet. And also, under our policy, have they earned 4 months worth of vacation this year? In other words, in January, every January, do I make a full allotment of the vacation available? Is it earned by the month? Do you have to be employed for the whole year and you get it at the end of the year in the following January? So we got to think about those things, past year as well as proration of the current year. Again, all a function of your policy. The other termination example that I see oftentimes is one of the things we want from people leaving is notice, right? We want notice 2 weeks, a month, whatever you have in your policy, whatever your notice policy is. Before you quit, we want 2 weeks notice. You can have a policy that says a failure to give the notice results in a forfeiture of the vacation. So, 45 years ago when I was a young labor and employment law lawyer, I thought, okay, well, I'll write a policy that says you don't give us notice, you forfeit any vacation that you've accrued. You don't get any payout for your vacation. I thought it was brilliant, and of course, people on the other side are just or better brilliant than I am about finding ways around these things. So what people would do is they get a job offer somebody that says, look, you got to start next week. They come to us and say, I've got 2 weeks vacation. I'm giving you 2 weeks notice. And today I'm going on vacation for 2 weeks. And they start the new job a week from now and they get the 2 weeks vacation because they gave us notice. Now, what's the purpose of the notice? The purpose of the notice is for you to make arrangements to figure out, maybe hire another employee, maybe train another employee temporarily, figure out how you're going to get along with this person, have them wind up their projects. We all know the good reasons why we want notice before somebody leaves. So now, next chess move in our drafting of these policies is we had a clause that says you have to give us 2 weeks notice and you cannot use any vacation during the notice period, right? You have to give us 2 weeks notice and you have to work. And if you don't give us 2 weeks notice and you don't work during that period, you forfeit the vacation. So at least if the person, I've had this happen several times, they had to leave to accept the other job, at least you don't have to hand them all the vacation money on the way out. And that's a little bit more palatable where you haven't got your notice. There's certain things we're paying for this paid leave. I mean, it's your money. You don't have to give it to them. So you can attach some strings that are reasonable. You want to make sure you put the notice, these policies that I'm talking about, we want to make sure they're in writing, we can prove they've been distributed. However you do that, I have some imaginative clients that rotate some of these policies under New York law that we have to have in writing, and they have them pop up on the computer screen. Instead of Andy's picture of his daffodils, struggling in the snow. Today, the vacation policy pops up, and they have a record that it showed up on people's screens. I'm not sure how much they read it, but it popped up. Same thing with the sexual harassment policy. Every day, there's a little different pop-up screen as a reminder. It's a little extreme, but it comes in handy when people say, gee, I didn't know that was the policy. But again, the handbooks, postings, so on. There is a provision, a little known provision in the New York wage regulations and guidelines that says, with respect to something like a vacation policy, you can have an oral policy. You can also have a past practice. Now, I've had several cases where there was an issue on vacation pay, and I've never been able to win the oral practice or the past practice situation. It's a long shot. I mean, it clearly says the burden's on us to be able to prove it. It's a tough one. I mean, this is an area where it's important to make sure we got it in writing. Another reason, frankly, to have a handbook. This is one of those policies that we want clearly spelled out, especially forfeitures under the law. You certainly can have policies that require people be employed as of a certain date to be eligible for vacation. You have to be employed on the last day of the year, December 31st. I had this was a terrible union case. I had a gentleman that died, and there was a significant amount of vacation pay, roughly $30,000, I think, at stake. But the policy said you must be actively employed on the last day of the year before before your employment terminated. And in order to be eligible for these blocks of vacation. And unfortunately, the gentleman died before. I mean, it wasn't one of those great cases that you want to brag to your children and grandchildren about taking money away from widows and children and so on. But that was the contractual relationship, and that's what had been negotiated with the union, and that's what prevailed. Under New York law, that was a valid requirement. Sometimes we have drafted policies where if you just say you get this much vacation for being employed, there's a difference between active employment and employment status. So sometimes we have, you must work at least 20 active weeks in the preceding year to get the vacation allotment, or 30 weeks. Those are legitimate requirements. We may run into different situations, although it holds up for most, whether it be workers' comp, disability, even Family Medical Leave Act. It's a matter of earning the benefit by working, just like wages. I don't have to pay people when they don't work. If you cast the policy correctly, you can limit people's eligibility where they haven't actually worked. That's been very significant. We had a huge case for a client that I represented and did the negotiations where we had a 6-month strike for about 1,000 people. And the strike went on for about 8 months. So there was a ton of vacation money at stake. And the question was whether they had earned the allotment. They were still all employees, even though they were on strike. And the board brought a proceeding against us saying we discriminated against the strikers because we gave the people across the picket line and worked and the replacements vacation. And they said, you have to give it to the strikers too. And we proved that we had a past practice of not giving it to people that were on disability, comp, or layoff. In other words, it was active versus inactive active or inactive employment that was the difference, not whether we retaliated against you because you decided to strike, which is protected activity. So that came in handy that we had that past practice, unwritten policy, but that's how we had interpreted the labor contract. Employment meant active employment, not inactive employment. And it was in the nature of wages.
So Lou,
yeah,
that was, I think, the big takeaway I have is the policy's key. It's one of these areas, as you noted, where we still have some flexibility as employers. We got a couple questions from people that are asking about PTO, right? We've seen a lot of our clients who have moved to this kind of general PTO bucket rather than vacation or separate sick bank. And we can talk about paid sick leave separately too. But when it comes to PTO, do these same rules, the question that they're asking, these same rules apply here?
That's a good question. It can for vacation and holidays. Holidays fall into the same category they fall in the same category, but we end up giving the 4th of July and the 4th of July. So it's a little bit less us approving the time off and so on. But holidays fall in the same category. New York state law does not require that an employer pay for holidays. It's, again, pay for time not worked. So we're given flexibility. On the other hand, and Andy, you would know this better than me, but you're going to run into problems with the paid sick leave. If your PTO includes paid sick leave, I think there's going to be some different rules that regulate how that 56 hours plays out and some of those issues. But certainly for the holiday, if you want to lump holidays and vacation together and eliminate those and call them PTO time, and it's easier for you to apply, yes, you could have rules that say it doesn't accumulate or this much carries over, or I don't pay it to you if I fire you. You don't earn it unless you actually work, all those kinds of things.
Yeah, I agree. And I
hope, Andy, you and Kathy Purdy have, screened out all the Department of Labor people and the government people, because as Andy said, this is one of the few areas. I mean, you go to California, your vacation rules, everything I've talked to you about today is out the window. New York, it's still the Wild West when it comes to you crafting your own vacation policy. So it's an area you should take a look at. And, again, it's a great benefit that you're offering your employees, which is pay for time not worked. And you should craft that the way it fits your culture, how you approve the vacation time, what the process is, how you cancel them, all those kinds of things, the entire regulation. I mean, there's a lot of money. As people know, you get into a significant workforce. It's not an insignificant amount of money, especially if you're letting it pile up from some previous years.
Oh, thanks, Lou. And one thing I've heard too is, as the labor market has tightened here in New York, a number of our clients have started to look at how much vacation time they're providing and when employees are eligible for it, to try to use it as a recruitment or retention tool too. So if you find yourself in that situation, it's a good time to take a look at your policy. And likewise, if you've listened to what Lou had to say, and I'm guessing with the hundreds and hundreds that we have on this webinar, someone out there is saying, wow, we don't have that forfeiture language in our policy, or we hadn't really thought about this, and it's just always seemed to work okay from this point. And maybe it can continue to work just fine, but it is a good issue to reach out to somebody like Lou and talk to on, because you're going to want to make sure that you structure things if you want to make changes prospectively. Again, that's going to be the key, the prospective nature of the changes. You're going to want to be thoughtful and have the advice of legal counsel when you do that too. So Lou,
again, there's some good material on the website, and chapter 4 of the book deals with vacations and some of the various issues.
Great. And we'll have links at the end, everybody, if you want to access to order the book through Amazon, and that'll be posted when we publish these slides too, so you'll have it there as well. So Lou, thanks a million. Good to have you with us again, my friend.
Thanks. Nice to be here. Thanks, Andy. Good luck, everybody. Be careful out there.
All right. So just a quick update on where things sit with COVID right now. Let's cover the United States first. I think overall, we've seen relatively steady. The numbers continue to be far, far lower than we saw in January, which you saw at the peak there during the emergence of the Omicron and Delta variants. The 7-day average has inched up. So the last presentation I gave on my week was back on the 4th of April. The 7-day average was about 19,000. We're seeing some variation in that from day to day, week to week. Now it's on a national level up to 27,000, and you see an aggregate of 54,000 cases in the United States. Now, the more interesting slide to me is the New York one. And here at the bottom, as may not come as a surprise to everybody's following the news, we do see that slight increase in the slide where before it had been declining or staying steady. And we see that 7-day average creeping up almost double from what it was back on the 4th of April. Again, good news, I think, when you look at this is that we're still far, far lower than where we were, but obviously we'd like to see that trend differently. The other thing I noted here, when I look at the aggregate number of cases, and we're talking about 11,000 plus cases in New York, well, going back to the US, I mean, it's only 54,000 cases in the entire US. So we're seeing about a fifth here in New York of the aggregate cases. And the next slide I want to show you is what we're seeing on the county based on the CDC's new threat assessment level. And when I last presented, in the lower left-hand corner, you see the state map, and it was really concentrated in central New York, that being the areas of high risk as categorized. And of course, from the CDC's website this morning that I pulled as of yesterday, we see that expanding as well. And again, anecdotally, not surprising, we've seen these numbers climb. I'm getting more calls again from clients who are saying, hey, we've got an employee who reported exposure, tested positive. Remind us again about what the protocols are. So again, keep those items handy. I did just include here a reference as to what the CDC is recommending. Again, these are recommendations, not requirements at this point. And again, what has remained in place thus far in New York with respect to no emergency designation from the state, no HERO Act activation, that all remains the same. Again, hopefully we see these trends move towards a more positive direction, but we'll keep an eye on things. All right. One thing I did want to just mention before we wrap up is we did see positive news with respect to air travel, that masking would no longer be required. CDC had sought to extend that, and Homeland Security has sought to extend that until early May. I think it was the 3rd of May, so they can continue the study. There'd been a legal challenge ongoing in Florida, and a federal judge there actually overturned this extension. And so as of yesterday, I believe masking was no longer required at airports and on airplanes. Looking at the news this morning, it was interesting to see that every carrier that I read about instantly adopted that ruling and said that masks would no longer be required. Again, stay tuned here. There may be more to see, but for now, hopefully a sign of progress and another positive development with respect to the pandemic. All right, everyone. Thanks again for joining us today. You see our contact information in there. If there's anything that we can do to assist you, please let us know. If you can take just 2 minutes and complete the survey at the end, let us know. Please provide your feedback and let us know what topics you'd like us to address if we're not covering them already. Thank you, everybody. Be safe and be well.